You're driving home, minding your business, when the familiar flash of red and blue lights erupts in your rearview mirror. Your heart drops. You think, I know my rights. I'll just stay calm, be polite, and refuse searches. But what if I told you that the legal playbook you're relying on is being rewritten page by page, and by 2026, the rights you think you have at a traffic stop might be nothing more than a comforting illusion? I've spent the last few weeks deep in appellate court rulings, proposed legislation, and attorney general advisories. What I'm seeing isn't a single law change, but a creeping, consistent judicial reinterpretation that is systematically transferring power from the driver's seat to the patrol car. This isn't conspiracy, it's case law. So, I have to ask you right now, because your personal experience matters here. What is the very first thought that runs through your mind the second you realize those lights are for you? Is it a cold panic, a calculated calm, or a simmering frustration about what might come next? I need you to tell me in the comments. That real, raw reaction is the starting point for everything we're about to break down. Personal and credential lead-in. Let me be blunt. In my practice, I've moved from defending traffic cases to almost feeling like a historian, explaining to clients how the rights they thought they had were chipped away years before they were even pulled over. They come in with viral video advice and phrases like, "Am I being detained?" only to find that the legal context for those phrases has evaporated. My job today is to bridge that gap between popular understanding and legal reality. We're not talking about far-fetched dystopian theories. We're talking about documented trends in courtrooms from the Supreme Court down to your local district court. By 2026, if these trends hold, the traffic stop as you know it will be a fundamentally different and more perilous encounter. Here's what's fading away. 1. The death of the pretextual stop challenge. Your reasonable suspicion no longer needs to be reasonable. The old understanding. For decades, the precedent set by Wren versus United States, 1996, was clear. Police could use a minor, valid traffic violation, a burnout license plate bulb, failing to signal for exactly 100 feet before a turn, following too closely, as a pretext to stop a vehicle and investigate a separate, unrelated hunch, drugs, guns, etc. The saving grace was that defendants could sometimes challenge the extent or duration of the stop if the officer's ulterior motive was blatantly discriminatory or the investigation strayed wildly from the original violation. The legal shift happening now. The emerging doctrine, crystallizing in cases like Kansas versus Glover, 2020, and being aggressively adopted by lower courts, is objective basis absolutism. The courts are now instructing judges to essentially put on blinders. The only question is, was there an observable traffic violation, however minor? If the answer is yes, the stop is per se lawful, and the officer's subjective intent, whether it was a hunch, a profile, or even explicit bias, is deemed legally irrelevant and inadmissible in court. This is being compounded by technology. Automated license plate readers, ALPRs, and AI-driven patrol car systems flag vehicles for expired registrations, insurance lapses, or even owner-associated warrants instantly. The pretext is now algorithmically generated. The stop is objectively valid because the computer said the registration lapsed 3 days ago. Why the officer chose to run that plate or act on that alert cannot be questioned. The 2026 reality. Imagine this. You have a bumper sticker for a political campaign. An officer sees it, runs your plate automatically via LPR, gets a ping for a malfunctioning third brake light they can't even see from their angle, and initiates a stop. In court, your lawyer cannot argue. Your Honor, the stop was motivated by viewpoint discrimination. The judge will reply, the brake light violation provides an objective basis. Motion to suppress denied. The legal tool to fight discriminatory policing at the initial stop point is becoming obsolete. My professional take. This is the most profound change. It decouples lawful from legitimate. It creates a system where virtually every driver is in perpetual violation of some hyper-specific traffic code, giving unlimited discretion to officers on who to stop, while removing the judiciary's ability to check why. The reasonable suspicion standard for the stop itself is being automated and hollowed out. 2. The Terry Frisk metastasis, from pockets to passenger seats under officer safety, the old understanding. Established in Terry versus Ohio, 1968, a frisk or pat-down was a limited, exterior pat of the clothing to detect weapons that could pose an immediate threat to the officer. Only if the officer had reasonable, articulable suspicion the person was armed and dangerous. It was not a search for contraband. For vehicles, the precedent in Michigan versus Long, 1983, allowed a search of the passenger compartment only if the officer possessed a reasonable belief the suspect was dangerous and could gain immediate control of a weapon. The legal shift happening now. The concept of officer safety is being stretched into an infinitely elastic justification. The key expansion is happening in two areas. The friskable area is now the lungible area. Courts are increasingly allowing searches of closed containers within the vehicle, glove boxes, center consoles, backpacks on the seat. During a weapons search, if the area is within the lunge range of a driver or passenger after they have been ordered out of the vehicle, which is a standard, lawful order. Since people are almost always ordered out for safety, the entire interior often becomes subject to a weapons sweep. If an officer feels a hard object in a console during such a sweep, they can often claim they believed it was a weapon, justifying its seizure and opening. Reasonable suspicion of danger is being presumed. In many jurisdictions, factors like the time of night, a high-crime area, a notoriously broad designation, nervousness, or the odor of air freshener, sometimes argued to mask drugs, are being aggregated to create a default suspicion of danger. This lowers the bar to initiate a Terry vehicle search dramatically. The 2026 reality. You're pulled over for speeding at 11 p.m. in a commercially zoned area, now a high-crime area, in court filings. You're nervous, of course you are. The officer, citing safety, orders you and your passenger out. He then conducts a protective sweep of the vehicle, opens your center console because it's within lunge range, and finds a legally prescribed medication not in its original bottle. This leads to arrest. The judge will likely rule the sweep was justified by the totality of officer safety circumstances and the discovery was lawful under the plain field doctrine extension. My professional take. Officer safety is an unimpeachable, powerful justification. Its expansion effectively creates an end run around the Fourth Amendment's requirement for probable cause to search a vehicle. We are moving toward a reality where any traffic stop, once the driver is outside the car, can justify a cursory search of the interior for weapons as a standard procedure. 3. The right to remain silent, but not without penalty, when silence becomes suspicious. The old understanding. Miranda is clear. You have the right to remain silent. Griffin versus California, 1965, established that a prosecutor cannot comment on a defendant's silence at trial as evidence of guilt. The spirit of the right meant your silence could not be used against you. The legal shift happening now. The loophole is being exploited during the detention itself, not at trial. The Supreme Court's decision in Salinas versus Texas, 2013, left a critical gap. Pre-arrest, pre-Miranda silence can be used against you if you invoke it ambiguously. The emerging trend is that officers are being trained to interpret silence or hesitation as part of the totality of circumstances, justifying further detention or investigation. Here's how it works. An officer engages in consensual questioning. Where are you headed tonight? Mind if I look around? If you a polite person, pause, say or I'd rather not say. That behavioral cue, unusual nervousness, evasiveness, is being logged in the officer's report as a factor contributing to reasonable suspicion that you are involved in criminal activity. It extends the stop from a simple ticket to a drug dog, walk-around, or more intensive questioning. The 2026 reality. The right to remain silent now requires a precise, legally cognizable invocation. A mumbled, "I don't want to talk," might not suffice. The safe harbor is the explicit, unambiguous statement. Officer, I am invoking my Fifth Amendment right to remain silent, and I wish to speak to a lawyer. Anything short of that, hesitation, partial answers, or confused silence, can be weaponized to prolong the encounter and increase the scrutiny you face. My professional take: this turns a fundamental right into a procedural trap. It demands a level of legal poise and knowledge that is unrealistic for most people in a stressful, authoritative encounter. The right exists, but exercising it imperfectly can now directly cause the very escalation you hope to avoid. 4. Consent searches. The mirage of voluntary agreement under pressure. The old understanding: consent must be voluntary and not the product of coercion. While the burden is always high, there is an understanding that a reasonable person should feel free to refuse. The legal shift happening now. The legal standard for voluntary consent is being eroded by a focus on objective factors that heavily favor the state. Key developments: the demise of clear and unambiguous. Your consent can be implied. A nod, a shrug, stepping aside without objecting, or even remaining silent after an officer says, "I'm going to take a quick look, okay," have all been upheld as valid consent in various jurisdictions. The courts often rule that a reasonable officer would interpret your non-resistance as agreement, the officer-friendly tone as a shield. Prosecutors successfully argue that because the officer was polite and professional, the consent could not have been coerced, ignoring the inherent psychological pressure of the armed, uniformed authority figure controlling your freedom. You can be misled. Within limits, officers are not generally required to inform you of your right to refuse consent. They can use phrases like, "You don't have anything to hide, do you?" Or, "If you just let me check, we can get you on your way faster." While outright lies might invalidate consent, strategic, pressure-applying truth, "I can call for a K9 unit if you'd prefer," does not. The 2026 reality. The magic words are no longer yes. The magic words are clear, verbal, and no. I do not consent to any searches. Silence, ambiguity, or passive compliance will be read as a yes. The entire dynamic is designed to make refusal feel like an unnatural, confrontational, and suspicious act. My professional take: this area represents the greatest gap between legal theory and on-the-ground reality. The law says consent must be voluntary. The practice rewards officers for creating an environment where refusal is socially and psychologically difficult, and then the courts ratify the results. True voluntariness is disappearing from the equation. The 2026 Survival Protocol, a lawyer's step-by-step guide. Knowing what's being taken away clarifies what you must firmly hold on to. This isn't about winning an argument on the roadside. It's about preserving your rights for the fight in court, where you have a lawyer and a judge. Step 1. The mental prepare. Understand that the goal is not to beat the cop. The goal is to be a calm, compliant, and closed vessel of information. Your mission is to provide the legally required documents and otherwise end the interaction as swiftly as possible. Step 2. The safe and compliant initial action. Pull over safely, turn on your interior light, if at night. Place your hands on the wheel. When the officer approaches, have your license, registration, and proof of insurance ready if you can reach them without sudden movements. If not, tell the officer where they are before you move. Comply with all lawful orders. Step out of the car. Keep your hands where I can see them. You can and should comply with commands for physical safety. Step 3. The verbal script, your essential shield. After providing documents, the officer will often engage in friendly chat. This is the critical moment. You must deliver your script clearly and calmly. "Officer, I am going to remain silent. I do not consent to any searches of my person or my vehicle. I wish to speak with a lawyer." Then you stop talking. Do not elaborate. Do not explain. Do not argue. If asked further questions, you can politely repeat, "I have chosen to remain silent, and I would like a lawyer." You have now invoked your core constitutional protections in a way the courts must recognize. Step 4. The post-stop action. Write down everything you remember immediately. Time, location, officer's name/badge, from ticket, what was said. If you believe your rights were violated, e.g., a search after you refuse consent, your mantra is, fight it in court, not on the curb. Hire a lawyer who specializes in traffic and Fourth Amendment law. The suppression hearing. where your lawyer argues the evidence should be thrown out due to an illegal search, is where the battle for these fading rights is actually fought. The larger battle, why this is happening and what it means. This shift isn't accidental. It's driven by a judicial philosophy that prioritizes law enforcement efficiency and officer safety over individual privacy in the context of vehicular travel. Cars, the courts increasingly reason, are heavily regulated, mobile containers in which individuals have a reduced expectation of privacy. This principle, established in cases like California versus Carney, 1985, is the wedge being used to widen police powers incrementally. The integration of surveillance technology, LPRs, drone monitoring, facial recognition in patrol cars, provides the objective data to justify these stops and searches at scale. The legal framework is adapting to facilitate the technology, not protect the citizen from it. Final call to action and discussion. This is a conversation we need to have legally and publicly. Awareness is the first line of defense. So, I'll end with the question I want you to grapple with in the comments. We all know the classic advice. Be polite, don't consent to searches, ask if you're free to go. Given what you've just read about how these interactions are evolving, what single piece of that classic advice do you think is now the most important, and what piece might be outdated or even dangerous? Let's dissect the old playbook in light of the new rules. Remember, knowledge without a plan is just trivia. Arm yourself with the script, understand the trends, and share this knowledge, because in 2026, the driver who knows the new rules of the road will be the one who survives the encounter with their rights and their future intact. Disclaimer: the information contained in this article is for educational and informational purposes only and is not intended as legal advice. The law is constantly changing and varies significantly by jurisdiction. No attorney-client relationship is formed by reading this article. You should always consult with a qualified, licensed attorney in your state regarding any specific legal situation you may have. The scenarios described are based on analysis of emerging legal trends and should not be taken as a prediction of any specific court's ruling.